It is an honor to be invited to present this winning paper on third party funding. To set the tone, allow me to borrow the words of Dr. Samuel Johnson, whose work pioneered the English dictionary. In 1755, Dr. Johnson responded to the belated flattery of the Earl of Chesterfield. He had earlier ignored his request for patronage. Is not a patron, my lord, who looks with unconcern on a man struggling for life in the water, and when he has reached, encumbers with him with help. Dr. Johnson's rebuke in a letter that declared his independence decreed the sort of patronage that gives assistance only when it is no longer needed. I recall this because the analogy is befitting. Third party finance is being marketed as a benefactor to investors, yet it all too often encumbers the very system it purports to assist. It is to that phenomena that we now turn. In modern form, third party funding allows a financier, usually a hedge fund, to pay for a claimant's legal costs in exchange for the share of the award. When used to help impecunious parties to vindicate a meritorious claim, it can facilitate access to justice. However, the reality of contemporary investor-state arbitration is often different. In Ecuador Minerals versus Colombia, the claimant's costs amounted to 33 million US dollars. Much of its costs stemmed from a funding arrangement under the financier, which was entitled to a 50% of the award. Such arrangements risk subverting the purpose of investor state proceedings by allowing third party funders with no relationship to the investment or the host state to control litigation. This problem is not the existence of funding per se, the funding and is justified, but it helps enable an impecunious party to bring a legitimate claim, as witnessed in Tanvir versus Argentina, which reports a similar concern expressed by Dr. Kamal Hussain, who described the creation as gambler's nirvana when funders can profit from awards without facing costs from courts. The problem is aggravated by the current inability to transfer tribunals to make awards against funders. In other words, funders can gamble with impunity. The ICC rules of 2021 under Article 11.1 offer some respite. They request or demand, shall we say, prompt information to the Secretariat or Tribunal and the other party of the existence and identity of the funders with an economic interest in the outcome. Article 22.1 imposes a duty of the tribunal and parties to conduct the arbitration in expeditious and cost effective manners. These clauses are sensible. They shine light on the conflict and announce a culture. But light and culture do not, by themselves, change behavior. For there, we need governance, not disclosure. We need a change in behavior with incentives, not with slogans. IBA guidelines of conflict recognize this new reality. General Standard 6B treats a third party funder or insurer as a person with a direct economic interest in the award. They offer a conflict hygiene, not discipline hygiene. It helps us avoid the surprise connection that derails an appointment. It does not stop the slow bleed, endless with document requests, expert inflations, and the strategic adjournments funded by someone who is not writing the tribunal's checks. Visibility without responsibility is a half measure. In corporate terms, we have compliance, but not governance. So I propose three pillars within practice, not above it. Pillar 1 is funder accountability. The ICC does not need to read funding agreements like sermons. It can, however, require a short certification. The funder should confirm due diligence on merits, counsel capacity, and proportionality, and confirm no control rights over pleadings, evidence, arbitrator selection, or settlement. Why? Because courts have shown they will treat funders as real actors. In Arkin versus Rocket Lines, the Court of Appeal held that a funder may be potentially liable for adverse costs to the extent of the funding provided. If liability can be capped, responsibility should be declared upfront as well. Excalibur makes the point with less sympathy and better prose. In Excalibur Ventures versus Texas Keystone, the Court of Appeal notes that funders who follow the fortunes and have to derive a small fortune cannot complain when they follow the fortunes on cost. The court emphasized the funding is a business, not a charity, and that due diligence must be rigorous. This logic translates cleanly into ICC arbitrations. If funding is professional, its governance should also be professional. A certification regime is a way of asking whether the homework was done or not. The second limb of Pillar 1 is tranche discipline. Many funders pay by milestones. The trick is to choose milestones that reward procedural quality, not procedural volume. Article 4 invites tribunals to consider limiting the length and scope of written submissions and to encourage the parties to consider settlement so the tranches can be linked to compliance with the procedural timetable, narrow custodian lists, and proportionate document production, and a mild case settlement cadency review. Put more bluntly, the checkbook should applaud restraint. A funded claim should run like a business plan and not a doctoral thesis. Pillar 2 is tribunal empowerment. Tribunals cannot bind non parties, but they can manage risk. First, a modest Article 11.7 can permit an in camera disclosure of limited funding features when reasonably necessary for independence, timetables, and costs. Tribunals should also feel confident for treating these as relevant cost allocations under Article 38. The English courts, in this regard, in SO versus Northcott, upheld the arbitrator's view that no costs can include the costs of obtaining funding for litigation. That does not make funding costs automatic, it makes them arguable and therefore manageable. It also nudges funders towards earlier realism. Pillar 2 answers the defaulting party problem. Article 25.2 states that if a party, although summoned, fails to appear, the tribunal shall have the power to proceed. Yet, proceeding is not enough. The record must show fairness. Model Law Article 18 requires that parties be treated with equality and given a full opportunity to present their case. The language reappears in Article 51B of the New York Convention, where enforcement can fall if a party was unable to present its case. The funder claimant, therefore, must buy discipline, not drama. The award may wobble. Pillar 3 is stakeholder oversight, and it sits with the ICC Secretariat, not the tribunal. Think of it as a light touch of corporate governance. A small internal committee could maintain a confidential register of active funders in ICC cases, recording identity, beneficial ownership, and the jurisdiction of the organizer. It should also record any tribunal observations, strictly limit conduct to relevant costs and case management. The register would not be public. It would not reveal pricing. It would simply allow patents to be seen and repeat conduct to be discouraged. It turns anecdote into data and data into accountability. Ladies and gentlemen, I return to Dr. Johnson. You must not wait until the swimmer reaches the shores before offering help, nor must we encumber him with assistance that drags him down. We must offer sanity, clarity, efficiency, and most of all, fairness. Thank you very much.